is so overwhelming. Like drafting your own documents is pretty impossible to do. And I see it a lot. In fact, I would say it's a mistake to try and draft your own documents usually, unless you have some sort of legal knowledge or background. And it's very rare you'll get it right. So often what I will see is people drafting their own and they have no idea what laws they need to comply with and then how to draft that. I see them copying off other people that they think maybe have had it drafted by a lawyer, and then have they been drafted by an Australian lawyer. So I see a lot of documents that have like Californian law in there and they haven't even taken that out. So laws are very jurisdictional. So what applies in Australia is going to be different in New Zealand, is going to be different in America, Canada, etc. So that's jurisdictional.
Hi, I'm Charlene Oy, dietitian turned business and marketing coach, and you're listening to the Nutrition Business Show. I've been a dietitian for over a decade, generated millions online, and we've helped thousands of health professionals. So if you're looking for a smarter way to grow your nutrition practice and create online programs to scale your business more sustainably, then you're in the right place. So let's dive in. Hello, Chantel. Thank you so much for coming on to the podcast today. It's so good to have you.
Hi, Charlene. Thanks so much for having me. It's great to be here.
Amazing. Chantel, why don't we kick off with you just doing a quick intro of yourself, letting our listeners know who you are and what you do.
Okay, so my name is Chantel Ryan. I am a business lawyer and I'm also a naturopath and holistic health coach.
What an interesting combination of qualifications and credentials. So did you initially qualified as a lawyer or a naturopath first? Which one came first?
Definitely lawyer came first. So funny story, I actually always wanted to get into health. So I was looking at doing health. I just didn't know where I wanted to be. I looked at doing medicine, but I hated chemistry back in high school. So I let that put me off. And then I really loved natural medicine. That was probably always where I was going to end up, I think. So I've kind of circled back later in life back to where I was initially kind of looking to go. But I decided to do law instead. I really loved all those law shows back in the day, like Ally McBeal. And so, and I loved debating and arguing. So I thought that was a good fit. And so I did my law degree instead and, loved working in law and have continued to do so. But after a while, I sort of got the itch to go back to the health side of things and my true sort of passion and love. So I've moved back into that space and studied in that space. And then I've sort of was going to leave law for health. And then I decided to sort of combine the two. And now I help practitioners with their legals, which is nice. I saw a gap there, a space there when I was studying naturopathy, that a lot of health practitioners were struggling to understand the legal requirements of a business and what they needed in terms of contracts. So I just saw an opportunity to help with my skill set. So I have combined the two now, and I have a naturopath clinic, and I also still have my law firm that specializes in helping health practitioners with their legals.
That is so interesting. I love that combination. As you probably know, Chantel, like the legal side of things can be a scary space for us all. Health practitioners, I work with a lot of dietitians, nutritionists, and natural and wellness practitioners. And when it comes to legal stuff, we all always, it's overwhelming and scary. So I'm really excited to, ask you some of the questions that I often get today, so you can kind of share your experience and wisdom with our listeners as well. And I know you're going to do a really good job in breaking all the jargons down into very simple speak so we can all understand that. But first up, I would love for you to kind of share from your experience being a health practitioner as well. What are some of the common mistakes that you see other health practitioners in the private practice space make when it comes to the legal side of things?
First of all, I want to say it doesn't need to be scary. I think it's just people don't know what they don't know. Unfortunately, learn anything about the legal side of business when you study. You don't learn much about starting a business in general and all the factors that come with that. So, and legal is just a small part of that. It's part of your risk management kind of side of setting up business. So people get really overwhelmed because they don't know anything about law. It seems scary. There's law firms and big scary lawyers. And, so I understand it can be overwhelming. And that's where I try to help practitioners to say, look, it's not overwhelming, but you do need to get some help around it, professional help. Lawyers are trained for a reason and get paid the big bucks for a reason because they have to stay up to date with the laws. So, don't be too stressed and overwhelmed about it, but learn what you don't know. Like you have to with anything in business. You don't know how to do marketing. You need to get out and learn that. If you don't know how to do sales very well, you're going to need to learn how to do that too. So you just need to teach. It's just about teaching yourself or connecting with the right people who can help educate you on that. So hopefully it won't be as scary for everyone listening today. That'd be one tip I would give. Mistakes I see people waiting too long. So when you first start a business, they just think, oh, I'll wait and I'll set up the legal stuff later. I'll put legal contracts in place later. So I'd say that's a big mistake. Like, you really should be putting the legal contracts and things in place from the start of your business. I know it's an investment. I know that we have lots of costs up front to pay for when we're starting a business, but I would say see your legals as your risk management. They're part of like having insurance. You have to have insurance that covers you in the event of something going wrong. Same with your legals. They're part of your reducing your risk, limiting your liability if you do get into trouble, and just having a clear set of documents you can use with your clients. And it just helps take that emotion out of that side of things with your clients. You can have an objective kind of set of terms that is helping you comply with law, set out obligations for clients, and it just takes that emotion out of it, I think. So getting your legals done at the start would be my advice. If we have listeners that a few years into their business, or even 15 years into their business, they don't have legals, any time is good to get them sorted. But if you can get it done from the start, that would be the best way, I think. So that's a common mistake I see.
Yeah, and I would say the best time to get your legals sorted would be yesterday, right? You don't want to wait till trouble comes knocking, a client's asking for refund, or someone's coming to you trying to dispute something to make that happen. And this is something that I have discussed with my clients in the past. Some people don't know about what types of agreements and legals they need to have in place before they start. So they just get started, start seeing clients, and then when trouble comes knocking, they panic. So Chantel, I'd love for you to explain to us, because there's so many different types of agreements out there. So shall we break it down perhaps for someone who is at the start? So if we're working with clients just consult-based, one-on-one, what type of agreements do we need to have in place?
Okay, so if you're working with someone one-to-one, usually that's fairly what I would consider a kind of low ticket offer. So that's something that can be covered in your terms of sale. So you'd have a terms of sale, which is a set of terms and conditions that sets out all the terms and conditions around your offering. So all your goods and your services. So you would cover your one-to-one consults would be a service that you cover in your terms of sale. So I would say a terms of sale would be good for one-to-one consults.
Mm-hmm. So how about packages? So if we want to transition to perhaps selling a bundle of one-on-one sessions with some messaging support, and maybe they get some extra stuff from us, but it's still one-to-one in nature, would the terms of sale be adequate?
Terms of sale is adequate for any of your goods and services, really, however you want to do it. But as we kind of get more into the high ticket items, and the more investment a client puts in, and the more risk for you in terms of being paid and things like that, that's when you might want to look at a more individual sort of agreement with a client. But generally, you can cover everything if you want to in a terms of sale.
Mm-hmm. Would that include digital products of any nature? So if we were to sell like a self-paced course or a paid masterclass or something where it's still a low ticket because it's digital product in nature, would that still be adequate, or do we need to look at another type of agreement?
Look, it's really a preference thing, I think. So I have clients that are quite happy just having everything in the terms of sale. The only issue I'd say with that, if you have a lot of offerings and it starts getting quite complex, you do need to keep your terms of sale up to date. So that's something that if you are putting everything in there, that's fine. As long as you've got the right things in there, you're covering everything, all the terms you need to cover, and you're updating that fairly regularly. If they're quite simple, even if there's a lot of different ones like digital products, and maybe do some consults, maybe sell some supplements via a third party like site, you can cover all of that in your terms of sale. If you want to, you can then have a separate agreement with a client. So if you do a coaching, or you have a package, or you have a program, even if it's low ticket, you might just decide you'd prefer to have an individual agreement with each client, or you set out all the details in that, and you have the client sign. So it's really a preference thing. You can do it all in terms of sale, and some people prefer to do it that way, but you do need to stay on top of any changes to your offerings, because you don't want to have the terms of sale up there, set and forget, and then you are changing your offerings and then not remembering to go and update your terms. That's something that I can see happen. I have seen happen before, and then that can be really detrimental. So that's where a coaching agreement, sometimes because it is one-to-one, you're looking at that each time you're sending it out to a client a lot of the time, or you're sending the same one, so it's one document that you need to update, as well as your probably terms of sale for more your low ticket stuff. But if you do have a sort of individual coaching or client services agreement, obviously you can keep that up to date a little bit. Sometimes it's a bit easier to keep that up to date. And people prefer that sometimes to have it signed by a client. So it's really a personal preference thing. Both are fine from a legal perspective, as long as you have something in place. That's the main thing.
Yeah, so having something in place is really important because it outlines the terms and conditions, the expectation for the client, and also for the practitioner as well. So I'd love to dive into this a little bit more and chat about how do we get this agreement to the client. So you mentioned a little bit about sending it to them to sign. Sometimes, people would ask me, do I just put it on my website where they tick a box on checkout and say, yep, agree to that? Or do we need to send it to them to sign all the time? So my question to you is, does it differ with the price point as to how you send it to the client?
No, it's a preference thing. I would say, so a lot of what I usually advise my clients is if you're having a terms of sale on your website and that's going to cover everything, a tick box is a great idea. So you want some sort of acknowledgement from the client that they've read and accept your terms of sale before they book in, or at the time of booking, before you receive money from them. So you usually want to make sure that you've got that at the point of purchase. So whether you're emailing that with your first booking and you're booking initial documents, or at, on the site where they book in, or you're emailing it if they call you on the phone and book in. So you just want to make sure that they have access to that terms of sale. If they actually choose not to read it, that's up to them, but you do want some sort of acknowledgement that they've been given a link to the terms of sale, or they've been given a copy via email if you don't have a website. Do these days, I hope, but as long as there's some acknowledgement from the client that they've received those terms and they understand that the terms apply to the booking or to the purchase, whatever that might be. So yes, a tick box on the site at the time of booking or purchase is great. You can get clients to sign it. That can be kind of onerous to do that. As long as you don't need to do that, as long as you do have that very clear that your services and goods are subject to that terms of sale. That's the most important thing. Of course, if you do have a services agreement with a client, like an individual client agreement, yes, you'll want that signed. In terms of what level pricing would you need to do one or the other? You don't have to. There's not a particular sort of price point. I would say you need to switch from one to the other, but I would say, for your terms of sale, you would do a tick box is great. At all times, I would do a tick box if you can. And then, as I said, if you're moving to the individual documents, whenever you're using those, get those signed. And yeah, that would be a general rule of thumb. If you can't do that, maybe an email back that they understand that as part of your booking. Sometimes I've seen it, or I do it in my own client questionnaire, my initial questionnaire for consults with a client. I actually put as one of the questions at the bottom, legal. Legal is one of my, you might have health questions you ask them of different areas of health. I have legals at the bottom where I say, and agree to the privacy policy in terms of sale, and then I link it again. So I have a tick box, but then I also have that there. So I've got it on the paperwork and they've signed that paperwork, or they've submitted it to me and they've ticked that box. And if they don't tick that box, then I have a chat with them. So yeah, you can do it in multiple ways, but definitely the tick box is the easiest way for a lot of people. You can usually do that with your website developer, or if you're building a site yourself, it's fairly easy to add that in, I think. And then the higher ticket stuff, I would say if you're in the thousands of dollars for your packages and programs, good idea to get a signed agreement or signed conditions.
And there are so many different platforms out there to send contracts these days. Like I use Dropbox Sign myself, used to be HelloSign. For a lot of practice management software, they've got the ability for you to send it to them, to the client as well, and then they can sign off to acknowledge that at least, they're clear on those terms before they make the payment. And that's what I want to emphasize, because sometimes it's more of an afterthought. After they've paid, then we'll send them the contract to sign. So no, it has to happen either at the time of payment or before. So thank you for emphasizing that. So we talked about the client service agreement. What about your website? So when someone's setting up their website, so there are different things out there like terms and conditions, privacy policy, disclaimers. So can you talk us through the differences between each one's in very simple terms?
So website, definitely you need a privacy policy first up. So as health practitioners, we are collecting health information from our clients, which is considered sensitive personal information. So everyone is required to have a privacy policy. So it's a legal requirement. So number one, you've got to have a privacy policy. And that just is a simple document that goes through how your business collects and manages personal information. So that's from your customers, clients, anyone making inquiries, anyone that's sending you their personal information through your site or your business, that document will apply to them. So you have to be really transparent. There's certain legal requirements of what's going to be in that privacy policy, but it does need to be customized to your business in terms of how you're disclosing, who you're disclosing the information to and things like that, and where you're storing it. So there are some things that need to be covered off from a legal perspective, but number one, that you've got to have that. So that's a real legal requirement. You can get fines, and they've actually increased fines recently if you're not having a privacy policy. So probably low risk you're going to get caught out, but these days people want to see a privacy policy. They expect to see a privacy policy, with all the data breaches recently from really big companies that, have all these things in place. and things can still go wrong, that's where you've got to really be on top of these sorts of things. Have your policy in place, and more importantly, have the right procedures in place to ensure you're looking after your client data. Like a policy with sloppy procedures is not going to work. You want to make sure you are storing client files. If you have hard copy files, locking it away. Who has access to those files? If you're storing everything online, do you just have it on your desktop and anyone can come in and sort of open those client files? You should be having password protected files. Or if it's in the cloud, how can people, is it on your phone and people just access it? So you've got to be really careful of thinking of, where am I storing this information, and am I making sure that I'm looking after this information on behalf of my clients? So definitely that's the first one, privacy policy. And then secondly, we'd have a website terms of use. So your website terms of use is a simple, small document, about 1 to 2 pages. And that's all about a set of rules essentially for visitors to your website. So regardless of whether they become a client or customer, they might just be checking out a blog on your site. They might be looking at your services. They may later become a client or customer, hopefully, but they may not. So it's just a set of rules for anyone visiting your site. And that'll cover similar things to what's in your terms of sale. So, your intellectual property, just protecting what's on the site. So, your blogs and things like that, just noting your rights there. You'd have things like medical disclaimers, if that's relevant. You'd have any kind of password protected sections of your site. You'd cover that around looking after passwords and things like that. You'd have a few disclaimers on there as well. So that's your website terms of use. And then lastly, your terms of sale. So we've spoken about that a little bit today. Your terms of sale is your set of rules for anyone who becomes a customer or client and purchases something from you. So that's the difference between the website terms of use and terms of sale. So the word sale in there kind of is a way to remember it. Is terms of sale is when you're making a sale for your goods and services. And I separate the two. Sometimes you might see on some lawyers put them all in one document and just call it terms and conditions. I like to separate them because I think they do cover off on separate things. Some things that are relevant to people visiting your site might not be relevant if they're never going to become a client. And then some things that you want your clients to look at, more relevant to have it in terms of sale. So the terms of sale is your pretty important document because that's going to list all your terms and conditions around what you're selling. So it's going to have all the consumer law requirements. So you need all the correct wording in there in terms of refunds, cancellations, things like that. Obviously how to purchase from you, what's included, obligations of both parties in terms of the client relationship or the buyer and seller kind of relationship, depending on what your offering is. Payment terms, if there's any payment plans, any kind of communications, boundaries, things like that. You might have some specific terms that apply for consults. You might have some specific terms for packages, programs that differ from maybe some of your more general terms. Then you'll also want to have all your legal kind of protection stuff in there that will help reduce your legal risks. So things like your disclaimers, your medical disclaimers, your no guarantee of outcomes kind of clauses, your limitation of liability clauses, which sounds very legal, but it's basically if you get into trouble, it sort of limits your liability. A dispute resolution clause, so if there's any disputes between you and a client, how that's handled, the procedure for that. So you want to make sure you have that in there. That makes it very objective for both parties. Yeah, any sort of cancellations, refunds, as I've said. So yeah, that's a really important document to get right and a really important document to stay up to date. So it's those three: privacy policy, website terms of use, and terms of sale would be your main ones that you'd have on your website. Now you can pull out, I know you mentioned about a refund policy or disclaimers, you can pull out and have your refund policy stated on your website separately, but you need to make sure the wording is exactly the same as what's in your terms of sale and any other documentation. Like what I've seen a mistake clients make is having different refund policies, A, that don't comply with consumer laws, you gotta be careful, but B, also that different wording everywhere. So maybe there's a money back guarantee here and no refunds after this point here, and it's all over the place, and clients get confused and they'll pull out the one that suits them and say, well, it says this on your sales page, but your terms might say something different, and then you've got to honor the one that's on the sales page because that's what you've said. So being really careful there. So if you do want to have a refund policy, you want to pull it out, you want to have it on your website so it's really clear, that's fine, but just make sure you've got the same wording that you're using and that it's compliant with the law.
Yeah, thank you for summarizing that so well, because I think it's such a confusing space. First of all, with what you need to have on your website, and then versus what you need to have when you're working with clients. And I love how you talked about like being consistent with your wording. And the key here with legal is just making sure that you are being clear and upfront, isn't it, with your terms and conditions and all the different agreements that you have in place. So both parties are clear, and should a dispute arise, then we can all come back to this agreement that they've supposedly read and acknowledged because it's black and white in writing. So that's important. And then making sure that it's consistent across the board if you have it in different places. Yeah, because sometimes we update something and then we forget that we've got it in somewhere else. house as well.
But you're right. We definitely want to avoid one of the points, other than being legally compliant, with the laws and reducing your risk and limiting your liability. One of the main things is to prevent misunderstandings, which then lead to disputes. And that's usually where I see the issues is people that don't have contracts in place or don't have terms in place. They're the clients that are going to go after you and be like, I want a refund. And you'll be like, I don't know what to say here. So you'll just usually give the refund, and you might not have needed to do that. So I think it's like insurance. You hope you never need to use it. Usually when you have it in place, you don't need to. It's always the people that get caught out that don't have insurance that will get caught out. Same with legal documents. Most of the people most of my clients that have issues are the ones that have nothing in place or have very inconsistent documents, and clients see the type of clients that are problematic will see straight through that and utilize that to their advantage if needed. So
I always think of legal as having in place so you can go to sleep at night in peace, knowing that you've got everything covered.
Absolutely.
Yeah. Awesome. Now, Chantel, there are so many different agreements, and I know that it can be very overwhelming for us to know exactly what to write. There are so many different legal jargons in there, and sometimes you even talked about consumer laws. So I think it will be a really challenging area for someone who's starting out to write their own agreements. And thank God for people like you who's made legals very accessible for other health practitioners and business, because you've got not only do you have a one-on-one service with your legal side of things, but you also have a website where you sell legal templates. So I wanted to take a moment to quickly talk about that, because I can just imagine for our listeners who are hearing us talk, they're writing down lots of notes and it's hard to remember what to put in there. So do you want to share with us a little bit more about your Legally Healthy website?
Yeah, and this is why I created the templates, because it is so overwhelming, and people do, like, drafting your own documents is pretty impossible to do. And I see it a lot. People, in fact, I would say it's a mistake to try and draft your own documents usually, unless you have some sort of legal knowledge or background. And it's very rare you'll get it right. So often what I will see is people drafting their own and they have no idea what laws they need to comply with and then how to draft that. I see them copying off other people that they think maybe have had it drafted by a lawyer, and then have they been drafted by an Australian lawyer. So I see a lot of documents that have like Californian law in there, and they haven't even taken that out. So laws are very jurisdictional. So what applies in Australia is going to be different in New Zealand, is going to be different in America, Canada, etc. So that's jurisdictional. So it's really important if you're in Australia, you have Australian law, Australian documents that have the Australian laws referred to in them. So yeah, you need to be really careful around that. So also, I know going to lawyers and getting custom services, getting things drafted specifically for your business can be really expensive. So that's where I was like, well, I'll offer that, because sometimes you do need custom documents. Sometimes people prefer that, but I wanted that kind of mid-range where it's like, instead of feeling like you have to go draft your own or go copy someone else's and you don't know what you're getting, my mid-range would be get a template that's drafted by an Australian lawyer, is compliant with Australian law, and also is drafted by a health practitioner as well, who, the health industry as well, and can make them more specific to the health space and to health businesses. So there is other template documents out there and businesses out there that do legal templates, but they can be quite generic, not tailored to the health space. So that's where I'm a bit different, is that, mine are specifically niched for the health space and relevant to the health space. So yeah, so I love that I can provide the templates to people that need them, and, they can be affordable and accessible, so you can rest at night. Like you said, I'm glad that, that's something I'm helping people do. Hopefully is rest at night. That's always good. And particularly as a naturopath, I always want people sleeping well. So if I can help provide that to health business owners, I'm happy. So yes, that's the templates. I have the custom legals if you need it, and I have the templates, a whole different range of templates, some bundles that do include all those documents we've talked about today, like the website. I have a website bundle that has the website documents in it. I have a get started bundle that has all the documents that you kind of want when you're first getting started. And then I have individual templates for sale. So you might just say, you know what, I just need a privacy policy, or I just need the website terms, or you maybe want to do one at a time because cost is an issue, and that's fine too. If that's where you need to do it, I'd rather you do that than not get them at all. And of course I do have payment plans too. So I think, you can always get them and pay it off over time, which I like to make that an option for people, because I know it can be really costly setting up a business. I know myself having several. So yeah, and then I also do have a free consult service where I offer a free 15-minute consult for people that are just like, I don't know what I need and please help. And usually they do know. Usually they've gone on the website, they've figured out which templates they need, but they just need, want that confirmation. So there is that service if needed as well.
And are your templates suitable for dietitians, nutritionists, or is it just for naturopaths?
No, it's for every kind of health-based business. So the templates come with a guide on kind of what the document is, why you need it, how to fill it out, and then what to do with it after you fill it out. So it comes with clear instructions for everybody. Some of the example text in there, so you customize it for your business, and I go through each of that, give you drafting tips, where to change, what you need to change to customize to your business. But some of the example text I'll give there is from the perspective of a naturopath. So that's because I'm a naturopath, I had to pick one. So, some of that will apply to all health practitioners. So some of the privacy policy stuff, for example, is all very, pretty similar. Like you'll just delete the things that don't apply to your business. It's not naturopath specific, but some of the examples might be more naturopath specific, but you will be able to go, oh, well, that does apply to me, that doesn't. This is what I need to put in as a dietitian, or this is what I need to change in terms of dietitian. I've never had anyone have any problems. I have people from all over different health, the dietitians, I have nutritionists, naturopaths, homeopaths, all types of different health practitioners use the template successfully, and I've never had anyone say that they've had any problem filling it out with the naturopathic kind of examples in there.
Yeah, the examples are good. And I certainly had clients who's purchased that and said that they've got their, like privacy policy or website terms done within 10, 15 minutes, because it's all so well explained and outlined. So you just kind of have to go through and fill in the blanks with your own business stuff. So that's amazing. And Chantel's already provided us with a discount code that you can use as well, especially for our clients and listeners. So I'll pop that in the show notes for you guys as well to use and have a look. Now, Chantel, the next question I want to chat about is a big one, because a lot of our clients and listeners, they're in the online space. They offer Zoom consults or, virtual consults to clients from anywhere in the world. So I'm going to use the example of Australia because that's where you're based. And so if someone is based in Australia, are they able to take on clients, say, in America, the UK, or other parts of the world? And if so, what are some of the things that they need to consider?
So absolutely. And the great thing about being remote and being so global these days, we can access clients from all over the world, or service clients all over the world. That's a preference thing. You may not want to do that, but if you do, that's obviously available to you. And legally, you just need to be aware of a few extra things if you are doing that. So firstly, I would say just check with your insurance that it covers you for the work that you do and the jurisdictions that you are working within. So if, some insurance policies will, for example, exclude consults or providing services to America because America's quite litigious. So insurance companies won't always cover you for seeing American clients. So double check that. There are some that will cover you. So if that's really important to you to market to America and you have some American clients or think you will, that's something to be really aware of. Check insurance, number one, that you'll be covered. So if anything goes wrong and you need to rely on your insurance policy, you can. So just double check that. Make sure you have really good, robust legal documents in place, like what we've been talking about today, and make sure your governing law, we call it, so the jurisdiction in which, if say there's a dispute between you and your client, which law will apply. Obviously, you want Australian law to apply for one, so it's really obvious that your products and services are governed by Australian law. If there's any disputes with clients, that Australian law will apply, and also how the dispute resolution process will occur. So obviously mediation might occur first in your country, globally, so you want to just make sure you have a clear procedure in there. So that just will kind of prevent people making bogus claims or whatever, because if you're in America, they're not going to want to fly to Australia to kind of come and have a dispute with you usually, unless it's really important, and you probably settle it before that happens anyway. But you just want to make sure, and that goes the same with interstate. So even if you're providing services across Australia, you want to make sure that your governing law is your state, wherever you're based your business. So if I'm in Perth, for example, I would make sure WA is my state sort of law that applies, and then Australian law will also apply. So yeah, you definitely want to be careful of that. There are some privacy policy considerations if you are collecting personal information from people in Europe. So there's certain laws that apply, the GDPR law that applies over there, which is just they have very tight personal privacy laws over in Europe. So if you are actively collecting and marketing to European countries, you will need to be aware of that, and you'll need to just put some extra clauses in your privacy policy around that, and you'll need to get some help with that to make sure you're compliant. So it's not just having a website, but that in itself is not marketing to Europe. But if you are actively kind of collecting clients from there, and you do have clients, then you will need to consider the privacy sort of policies of over in those countries that will apply. And I think that's the main considerations. There are a couple of little bits and pieces. Exclusion of the Vienna Convention. I won't go into what that is, but the Vienna Sales Convention is a United Nations document that applies. Australia is one of the signing countries, and it was more based around physical goods and having some kind of uniform kind of laws around sale of goods across territories. However, for kind of what the services we're doing, like one-to-one consults or digital products, doesn't really like suit. It's a very complex set of terms. So you want to exclude the Vienna Sales Convention. So my template already does that, just so you know. So my templates all apply. So if you do want to service globally, just so you know, my templates. And so you will need to check that if you don't use mine. If you're using other templates, that's fine. But ensure governing law is Australian, the state you're based in, you know, and ensure that you've thought about the privacy stuff and you've excluded the Vienna Sales Convention, usually is what you're going to want to do for overseas.
Can I just dive deeper into, I know you said you didn't want to spend too much time talking about the Vienna sales. So you were talking about digital products there. So what if practitioners, they order supplements and recommend that as part of their treatment plan? Would that apply?
Ordering supplements from Australia, or would they be ordering it?
So let's say if they are based in Australia and they're seeing a client in Australia, they're ordering it through an online dispensary. So something like Vitally, for example, would that be something they need to cover as well?
In terms of the Vienna Sales Convention is more across like different countries and having the uniform laws. So I would say either way, even selling goods like overseas, I wouldn't bother having. I would still exclude the Vienna Sales Convention. It's more complex. It puts in a whole set of rules you don't really need. So I'd probably still not have that. Just make sure you have the, you know, whatever terms you want in your terms of sale. So thinking about shipping and things like that, if you're sending products from Australia, you will need to think of shipping, exporting, time zones, how long it's going to take, delays, things like that. Signing up to other providers. So in the UK, for example, I have some clients there. So I've signed up and I'm a practitioner for the Natural Dispensary UK, and I send some of my UK clients supplements from there. So it might be easier sometimes to sign up as a practitioner in there and get them sent things from their own country. But then of course you've got things you need to make sure you're applicable with, you know, you're applying there. So the privacy laws, as we spoke about in Europe, making sure as I'm collecting that information that I'm careful to comply with that. But no, the Vienna Sales Convention, you'd want to exclude that regardless. But yeah, you will obviously need to make sure in your terms of sale, you're covering how you sell products. So if you are selling from those third party, like Vitally, Oborne Health Supplies, you know, that you have some disclaimers in there that shipping and all that is based on. They once they sign up, you do the scripts to them, but once they sign up, if they want any refunds with those products, obviously they're going to have to comply with those third party terms and conditions. So, and again, in my templates, I sort of have clauses around that.
I love that you've covered everything there. So we just have to get the template. It was sorted. That's the benefit of going through someone like yourself, because you've got that hands-on experience being a health practitioner. So you've already thought about all these nuances that only we know about as health practitioners. So that's amazing. You guys definitely have to check out Legally Healthy. Now, Chantel, next question for you. I often get people asking me, when do I start to trademark my business name or my program name? Then the second part of this question is, how is that different to copyright? So I will talk about copyright laws in the sense of social media, or people like, you know, buying a course and copying it and selling it as your own. So I'll talk about that as part 2. But part 1, can we talk about trademarking? Like, what does that mean to even trademark your business, and what does it protect you against?
So look, copyright is different. Copyright protects like original works like books, music, art from being copied without your permission. And it's an automatic right that applies. You don't need to register anything. Trademarks protect like your brand identifiers, like your logo, your name, slogans, and things like that. And your trademark kind of distinguishes your goods and services. And once you trademark something, it prevents others from using your trademarks without your permission. So both are a bit different. Copyright applies automatically, as I said. Creative works and trademarks, you do need to register with IP Australia. If you have a really cool brand name, brand logo that you
like
really
Nike
like, slogan, yeah, you just, you know, you've nailed it and you're like, I love this, I don't want anyone else using this. You know, it's a good idea to trademark. It's not that expensive necessarily. You can maybe do it yourself. It's a little bit tricky. I probably would get a trademark lawyer to help you anyway, but some people have done it by themselves. I would say if you have a really unique name, really unique brand, really unique slogan, yes, like Nike or something like that, definitely think of trademarking, absolutely, because it will protect you and you will have a legal right to protection. For business names, for example, we think when we register a business name, we have exclusive use of that business name. If someone's trademarked that business name already, you could run into issues there, because a trademark, when you have a business name, you don't actually get exclusive use of that name. So common misconception there. So don't just think because you've registered a business name, that's it, it's yours, and you know, to the exclusion of all others. Not true. You may want to go that step further and actually trademark it. And also when you register a business name, just double check it's not trademarked. Go onto IP Australia and do a trademark search. Just double check those words aren't kind of trademarked already, because then you could run into trouble. You finally come up with a business name, you register it, and then it's a trademark. So yeah, just be really careful there.
And does that trademark apply per country or jurisdiction?
Yes, so you do need to, you can apply for international trademarks. And yes, if you're doing business in America and things like that, you might want to, or in other countries, you might want to look at an international trademark. But yes, through IP Australia, it's usually just jurisdictional. So if you register in Australia for a trademark, it's just protected against Australia. And that might be fine for you. If you're just an Australian-based business, you're probably not going to care if someone in America has a similar name to you, because they're probably not going to get the same clients as you. So, and also sometimes you can have very similar trademarks, but in different areas. So you can actually register very similar trademarks in different, so when you register a trademark, there's different classes based on different services and goods. So if you're called Nike and you do shoes, that's different to Nike. Actually, I'll use a real example. Dove, well, Nike is a real example, but I don't have a comparison, but say Dove soap and Dove chocolate, two different classes of goods, and they can both trademark and have Dove. But you can have two Dove chocolate kind of food Dove trademarks sort of thing. So yeah, you can have different trademarks in different kind of classes and goods, as long as they're not in the same issue, if that makes sense.
Yeah, absolutely. I love that you used the Dove example, because that's so much easier for us to understand. We know those two brands. Now, what about copyright? So often get practitioners, say, oh, I'm worried about people copying my content on social media. I put out a post and a few months later, I see someone else, my competitor, putting out a similar post. So does your IP/copyright apply to social media? And what else does it apply to that protects your original work?
Yeah, look, any creative works can be copyrighted as long as they're original works. So, and it's automatic, like I said, it already applies. I would say if you have, look, it happens all the time in this industry. Unfortunately, I see lots of people in the health industry. I see lots of people copying, and it's annoying and frustrating if you've put lots of time into creating, this great program or package or content, and then someone copies it. It's really hard, and then really hard also to say you were the original too, because there's so much copycatting done on social media. Who was the original? It's like a recipe. You'll see the same recipe on different accounts, and then you're like, well, who came up with it first? It sort of starts getting to that point of, what's original, what's not. So I would say, with copyright, it does apply automatically. I would say with any copyright on your website and things like that, obviously you'll have your website terms that kind of definitely makes that clear that you don't want anyone copying. One trick you can do on website content, you can actually get plugins for your website, I think on WordPress and things like that, depending on who you're with in terms of your website, where people can't right click any content on your website. So, some people can right click and then copy content, and then, makes it easy for them to kind of steal your content. If they can't right click anything on your website, it makes it harder for them. So they might go to somebody else. So I'd say that there's things like that you do to protect your copyright on your website a little bit. Social media is hard because there's so much of the same content around. It'd be really hard to say that's my content. So I would say see it as flattery sometimes, unless it's a really serious breach that's really costing you money and is really breaching your IP. If it's little social media posts, I wouldn't worry too much about it. You are unique. Your business is unique. You're going to attract people that want to work with you and your brand. People will always connect with, one practitioner over another. It's not going to be relating just to one single piece of content. So try to see the bigger picture. It's, what you offer is unique, and because you're unique. So no one can copy you completely as a person. So try to remember that about little things. But, I certainly have had a client that had her whole program. She works with kids and she does a kids eating program for kind of fussy eaters and kids with lots of sensory kind of issues with eating. And she has a whole program, and a naturopath joined her program saying she wasn't a naturopath and her kid had all these issues, and copied the content and then went and sort of stole it and did her own program down the track. She hadn't sort of disclosed she was a naturopath. And so it was kind of tricky trying to work out what to do in that situation. And she had copied some social media posts that were pretty obviously copied. And so we sent a cease and desist letter, like just sort of saying, well, this is our copyright. We know you've been in this program. You weren't clear. You were misleading in terms of like your occupation. Here's the social media posts that we claim are sort of breaching our copyright. Please take them down. So you'd be really clear. You can send a cease and desist letter. You can probably do it on your own without a lawyer. It helps to do it from a lawyer, because I think people get more scared when they see a legal, they take it more seriously, I should say, if they see a legal letterhead. So I sent it on my letterhead with this particular client. And, we were just very clear about, this is our copyright, this is what we're claiming, this is our copyright, this is where we think you've breached our copyright, we want you, and then a very clear call to action of like, we want those posts taken down, you've been removed from the program because you were misleading in terms of your information. Unfortunately, she didn't have terms of sale in place, so she's learned now and she now has them. But, you want to be really clear in your terms of sale too, like who can join your programs, what's your questionnaires, do they have to put what kind of occupation out, so you can see if it's a potential competitor. And even then, you won't necessarily want to kick them out just because they have the same career as you, but you could have terms in there, for example, which I do in my terms of sale template. You would have things in there like, I don't think I have it in, no, I do have it in the terms of sale, something in there around this program or package or service is for the client's personal use only, can't be used to compete with my business, can't be used for commercial gain or advantage. So you can put clauses like like that in your terms as well that makes it really clear. And then you can point that out to a client. If they were in your program, I would say, in this example, I would use that. So we could have said, you're in the program, it wasn't to be used. You agreed and signed this. You were not to use this for your own commercial use and advantage or to compete with me. You have. And then we could have done a breach of contract. Also, she didn't have that, so we couldn't go down that path, but that's just something that I think is a key takeaway from that case particularly. And this lady took the post down straight away, nervous about having a lawyer contact her. But yeah, it is tricky because it happens a lot.
Yeah. And, true story, it happened to me in the past as well. I had someone somewhere in America and they translated stuff into another language. So, I found out afterwards and obviously sent a letter and things like that. And then they denied it and said, no, it wasn't me. It was my assistant and all of those kind of things. So, like at the end of the day, like I said, you want to have these legal things in place so you can go to sleep at night. People who are coming into your program are people who need it for their own personal use. If something does happen, disputes do come up and you see someone copying your stuff, the steps to take. And it's the kind of things that, you don't want to have happen and learn from the experience. You do want to prevent it and minimize the risk of it happening. It's not nice, like for me, having to go through the experience myself, but I learned from it. And now that's why I'm so big about legal stuff with my clients. I'm like, you got to make sure you set up from day one so you can go to sleep at night.
No, you're spreading the word. Good for you.
Yeah, awesome. And I'm so glad to have met you and connected with you as well. So you can share, your combined knowledge being a practitioner and a lawyer and make it so easy for everyone to understand. I wanted to quickly talk about the social media side of things as well, Chantel, because for some people who don't know it, if you do find someone copying your post or, like it's very similar, there is a form that you can submit to Instagram support to, take screenshots obviously of your post and their post and let Instagram know. And if Instagram does find out that, definite duplicate, then they can contact them to remove it for you on your behalf. And if it hasn't been removed, that's when I would encourage my clients to say, okay, take the next step, contact them directly.
Absolutely. If you can do that through I think you can do that through Facebook too, Facebook and Instagram. Yes, that's a good point. So if it's just a social post and that's all it is and you're worried about it, concerned about it being copied, yes, you can absolutely go through those steps first. I wouldn't just do a cease and desist on some social media posts. I would only do that usually if they're really copying a lot of your content, and you're right, if Instagram that are not sort of taking action, and if there's more to it that's maybe costing you money and things like that, you'd want to look down the legal channel and spend that money to protect your IP a bit more if there's more of a potential cost and loss to you.
Great advice. Thank you. Now, I've got a couple more questions for you, Chantel, and this one's a big one that often get asked, especially as licensed and regulated professionals. So there are limitations to what we can share when it comes to testimonials for marketing. So what can we legally share? What can we not share? So I'd love to hear your perspective as a lawyer as well, what you know about this.
Yes. So as you mentioned, there's a difference between registered or regulated practitioners like dietitians versus the unregulated professions like naturopaths, for example. So we'll just use naturopaths and dietitians. So the people who are registered, like dietitians, they're subject to the national laws, APRA laws, Australian Health Practitioner Regulation Agency. So they have certain laws and advertising guidelines around what you can and can't do in terms of advertising, and a ban on testimonials is one of those things. So and particularly when the testimonials are around testimonials about clinical services. So if there's, for example, comments about customer service or communication style, that's okay. But when it hits on clinical aspects, so an outcome, details of the service provided, it's a no-go. So generally, rule of thumb for regulated practitioners, unfortunately, is you can't collect testimonials to advertise and market your services, which is a bit of a shame. APRA actually have a really good flowchart on their website that actually, if you're not sure if you can advertise testimonials, you can actually go through that. So am I a registered service? Yes, no. And it's like a nice little flowchart that says, nope, you can't do it. Yes, you can. So even with the naturopath example, so say I'm a naturopath and I have a multidisciplinary clinic where I also have dietitians there and, maybe a whole bunch of allied health plus natural medicine. If I am then marketing or advertising my business in general, because I do have registered practitioners there, I won't be able to use testimonials, even about the naturopath. So even if it's just about the naturopath business, part of the business, you still can't. So once you're all wrapped up together, you definitely, and registered practitioners are included in that, you can't do the testimonials. But naturopaths and unregistered practitioners generally can. or it's less restrictive. You may still have some, your associations that you're part of, you may have some like sort of requirements there and there, advertising codes of conduct and guidelines. So I would check those. But generally there's less restrictions on being able to give testimonials with naturopaths and unregistered practitioners. So
yeah, and then we have PTs, nutritionists, nutrition coaches, fitness coaches, lots of people out there who are not regulated as well, which could be a good thing, but also can be a scary space as well. I suppose, if someone is promoting something and it's not ethically aligned, that can be dangerous as well. But we are here to do no harm as health professionals. So I'm presuming that everyone does their part in sharing evidence-based advice.
Oh, and look, and unregistered practitioners still have, even though they're not subject to APRA, they're still regulated, like self-regulated under the health. There's still, they can still get in trouble. It's just not by APRA. So there is still a health complaints commission that will look for things like that. If there's any kind of issues, any kind of misleading conduct, and there is codes of conduct that apply. And if they're breached, practitioners can still be reprimanded for that. So yeah, common misconception that there's unregistered means there's just no laws whatsoever. That's not true. There is still this is still some sort of regulations in place, just not quite the same as being registered. So yeah, so you still got to be careful. You still got to do the right thing. You still got to, that's right. You still got to work, practice ethically. You should be part of an association if you're unregistered, and you should still be following those codes of conduct, those national codes of conduct, state-based, codes of conduct.
So let's say if we have an example of Mrs. Jones, she comes to see you, she had a great experience, and she said that, I love Chantel and how she's helped me. She's very caring and she's given me great care. Would that be something that will be considered clinical outcomes, or is that more of a professional-based review? And that will be okay if we were dietitians wanting to share that type of...
Yeah, if it's around customer service or communication style, they're about the only things you're allowed. Anything that starts going into clinical territory, so even just, I think that last bit of the sentence that you said there, I think might start hitting on the clinical aspect. So anything to do with outcome or the service provided, not really. You could just say, great customer service, and really liked the style of communication. It's hard, but you could get, as long as you fall within those two, I would still do your flow chart and just see, there's more detail on what's required, what's considered clinical and what's not. But yeah, general rule of thumb, you can't do too many things, but you still can get some. You can get some aspects. You just have to word it carefully to make sure you're focusing more on communication style, customer service, generally, rather than they cured this and, my psoriasis is gone now and, I lost all this weight and, you can't talk about outcomes and things like that. So, but yeah, there's certain things you can definitely still collect in terms of a testimonial and still then advertise.
And I get where that's coming from, because we don't want people to look at that and think, I'm going to get the same result as Mrs. Jones as well. Just because Chantel helped her cure her psoriasis, it would help me to get the same result, and that can mislead them. So I understand where that's coming from. I'll be sure to pop that link as well, Chantel, about the APRA flowchart that you mentioned in the show notes so people can go have a look. Now, on to our very last question, Chantel. You've been in business for a while, and a lot of us are, here growing our business, and it's not always a smooth sailing journey. So I would love for you to share from your perspective as a business owner, what advice do you have for our listeners who are trying to grow their business? And sometimes, we've got difficult days, and sometimes, we go through those highs and lows. So what advice do you have for them?
Just keep going. No, it's so tricky. Look, being in business is hard. Okay. If anyone tells you it's really easy, they're lying. It is hard, but it's worth it. And, look, it's not for everyone. So you will figure out if it's not for you pretty quickly, I think, but also give it time. Like, business can take time to grow. Okay. It's not going to be overnight success usually. Just know that. It will take a bit of time. I think if you're always coming from the point of view of helping others, and that you're passionate about helping others, and that you're trying to help them solve some problems in terms of their health. I think if you're always approaching it from that space, I think it makes it, remembering your kind of why, I think it makes it really easy to kind of helps you to keep going, I suppose, in those hard days. Because I think if you don't have that why, it just can seem easier to just go get a job somewhere else and get a regular paycheck and the rest of it. But if you really think about your why are you doing it? Why do you want to, you're having your own business for a reason, and you're trying to help others. You're trying to help them solve something, whatever that might be in the health space. And people need it. They need our help. They need, we're a very unhealthy population, getting worse and worse in a lot of ways. People are living longer, but they're not living healthier, right? So people need our help. They need your help. You're very unique and different in what you provide. You may think you're doing the same as everybody else, but you're not. As I said, people are always going to be drawn to you as a person, and no one can take that away from you, your uniqueness. So whatever you're offering, there will be other people offering the same thing, but you're unique. The way you deliver it and provide that help, people will be drawn to you for that reason. So just be yourself, I guess. That's what I'm getting at. Be yourself, and just always remember your why in terms of wanting to help others and serve others and be of service. And I think you'll do all right. The rest you can learn, teach yourself, find someone else who'll help you with it.
Absolutely. It's all the skills and things that we may not know, like, running a business, growing a business, that we can get support with. But the mindset piece I find is the biggest thing. We're going to always come back to our why and remember the reason why we're doing this. And as long as we're coming from a place of service, I think the hard days will pass, won't it? Like, have all these challenges that you face and you put out the fires, but you go to sleep the next day. It's a brand new day. You get up and then, getting back centered to your why, and then you keep going. And each year will get better and better.
Yeah. And I think when you have those client results, when you help a client and then you are, they do come back to you and say, hey, you might not be able to advertise that testimonial, but, they might come back to you and be like, thank you so much. You helped with this, or, I wasn't able to do this. Now I can. Like, you'll get those testimonials. You might not be able to advertise, but it'll help you with your why, because you'll remember, like, I'm helping people and I am doing, look at, I've helped this one person. I want to help the next and next. And it's amazing the work we do.
It's that fulfillment that money can't buy. And that's why we're in the health profession. We're not doing it for the money. And I always say to my clients, you may not be allowed to advertise testimonials, but keep them, have a sunshine folder that you keep all these positive reviews, little feedback and little notes that your clients write you. So when you go through the hard days, I've had days where clients come to me in my practice and are like, I'm really struggling and my gut issues are not getting any better. I go back to that sunshine folder and think about all the amazing results my other clients have experienced, and it brings you back to keep going.
I love that sunshine folder. Love it.
Although I don't think I invented that term. I think I heard it from someone else and I went, oh, it's such a great idea. I'll keep it.
Love it. I love it. Yeah. I love the name, and I think it's so important, and it'll keep you going. Read that sunshine folder when you're feeling like business is hard and you're having a bad day and maybe clients aren't booking in and you're getting nervous. Read that sunshine folder and just bring it back to your why, just keep going.
Absolutely. Thank you so much, Chantel. This has been such an insightful conversation, and I really love how simple you made it sound, and legally healthy template shop that you've created as well, where practitioners can get access to affordable legal templates to help them get started. So I'll be sure to link that in the show notes. Is there any other final words that you want to share with our listeners, Chantel, before we wrap up?
No, it's been a pleasure to be here. I'm so passionate about helping health practitioners with their legals, and just get started now, sooner than late, rather than later, like get it in place, protect yourself so you can sleep at night. And thank you to you, Charlene, for like being a practitioner who, is taking your legal seriously. Obviously, we've worked together, you've had your own issues in the past and learned from those. And I think it's really great now that you're spreading the word to other practitioners, and you're passionate about that too, to really make sure they're protecting themselves as well. So thank you for that. I really appreciate that you're spreading that word too. And just go get your legals sorted. It's not that scary, I promise.
Yeah, I promise Chantel doesn't make it scary. She makes it simple. So thank you so much. We all want to be growing our business confidently and know that, we've got our bases covered and we can continue to show up to serve our clients clinically without having to worry about all the little dots that we haven't dotted and T's that we haven't crossed. You want to make sure you get that all sorted as your solid foundation before you get started. So as you scale your business, you've got a strong foundation to grow from. So thank you so much once again, Chantel. I will see you very soon and chat to you soon. Thank you. And thanks for our listeners for tuning in.